In every real estate transaction, documentation is the foundation of communication, trust, and compliance. Whether it is a purchase contract, a listing agreement, a lease, or a disclosure form, each document represents a legally binding commitment between parties. Because of this, timely delivery of legible copies of signed documents is not only a professional courtesy, it is a statutory requirement under Arizona law. According to AAC Section R4-28-802, a licensee must deliver legible copies of all documents related to the transaction to all parties as soon as practical. This rule ensures that everyone involved has a clear and accurate record of the agreements made, protecting both clients and the public interest. This obligation ties directly to the principle of acting expeditiously and without delay. As discussed in the previous section, timely delivery of documents ensures transparency and allows each party to fulfill their contractual duties within required timeframes. In real estate, time-sensitive actions such as depositing earnest money, conducting inspections, or securing financing depend upon each party having copies of executed documents. If a licensee delays delivery or provides incomplete or illegible copies, it can lead to confusion, disputes, or even contract cancellation. For instance, imagine a buyer signs a residential resale real estate purchase contract, but the buyer's agent forgets to send a copy to the buyer for their records until several days later. During that time, the buyer is unaware of the inspection deadline or earnest money due date and misses both deadlines. The result could be the loss of the buyer's deposit or cancellation of the purchase. In such a case, the agent could be disciplined by the Arizona Department of Real Estate, ADRE, for failing to perform duties in a timely and professional manner as required by AAC, Section R4-28-802 and ARS, Section 32-2153, A3 and 9, which address negligence and incompetence. The law specifically requires that copies be legible and delivered as soon as practical, which recognizes that real estate professionals often work in dynamic situations where immediate hand delivery may not be possible. However, in the era of electronic signatures and digital transactions, the expectation of prompt delivery has become virtually instantaneous. Through platforms such as SkySlope, Dotloop, or DocuSign, licensees can deliver signed contracts and disclosures within minutes of execution, eliminating nearly all excuses for delay. Brokers are also responsible for ensuring that these systems are in place under R4-28-1103, which mandates broker supervision and control of record keeping and transaction files. Legibility is another critical component of this requirement. A contract or disclosure that cannot be read clearly may cause legal misunderstandings or misinterpretations. For example, a photocopy of a faxed document with faded print might make a number in a purchase price or closing date appear unclear. If the buyer and seller later disagree about the agreed upon terms, the lack of a legible record could result in a contract dispute. To prevent this, licensees must verify that all copies are complete, clearly readable, and accurately represent the final signed version before delivery. This duty also extends to all parties to the transaction, not just the licensee's own client. That includes buyers, sellers, landlords, tenants, cooperating brokers, and escrow officers when applicable. The rationale behind this rule is fairness and transparency. Each party should have the same access to the documents that affect their rights and obligations. Delivering signed documents promptly protects the public from fraud, misrepresentation, or alteration of terms after signing. A significant related responsibility is record retention. Under ARS, Section 32-215, 1.01a, E and F, brokers must retain copies of all transaction documents for a minimum of 5 years from the date of execution. This record-keeping requirement allows ADRE to verify compliance in the event of an audit or consumer complaint. Licensees should promptly upload all signed documents to their broker's transaction management system to ensure that files are complete and readily accessible. A case that highlights the importance of timely and legible document delivery is Hoffman vs. Greenberg, 1991. In this case, the court found that failure to deliver a copy of an executed listing agreement to a seller resulted in uncertainty about the terms of the agreement and whether the broker had earned a commission. The ruling reaffirmed that delivery of copies is essential for enforceability and professional accountability. Best practices include reviewing each document for completeness before obtaining signatures, confirming all pages are included, and immediately providing digital or printed copies to all parties. Licensees should also document when and how copies were delivered, whether through email confirmation, electronic signature platforms, or personal delivery receipts. This documentation not only satisfies ADRE audit requirements, but also protects the licensee from future disputes. Review summary. Delivering legible copies of signed documents promptly is both a legal and ethical obligation for Arizona real estate professionals. This duty ensures transparency, reduces risk, and maintains the integrity of the transaction process. Under R 4-28-802, copies must be legible and delivered as soon as practical to all parties involved. Delays or omissions may result in disciplinary action under ARS, Section 32-2153A3, for negligence or incompetence. Timely, clear documentation is essential for meeting fiduciary obligations of reasonable care, disclosure, and accounting. Ultimately, this responsibility protects both the consumer and the credibility of the real estate profession. Discussion prompts. Why must copies of signed documents be legible and delivered promptly? Answer. Because legibility ensures clarity of contract terms, and prompt delivery allows all parties to meet deadlines and fulfill obligations, preventing disputes or harm. What tools can help licensees comply with document delivery requirements in modern real estate practice? Answer. Transaction management and e-signature platforms, such as SkySlope, DocuSign, or DotLoop, facilitate instantaneous and verifiable delivery of documents. How can failure to deliver copies promptly lead to disciplinary action? Answer. It may be deemed negligence or incompetence under ARS Section 32-215-3A3, especially if the delay results in missed deadlines or client harm. Closing remarks. The delivery of legible, signed documents is more than administrative formality. It is a demonstration of professionalism and respect for the client's interests. Real estate transactions rely on trust, and trust is built through timely communication and transparency. By promptly providing all parties with clear, accurate copies, licensees fulfill both their legal obligations and their ethical duty to act with diligence and care. In a field where every document counts, every minute counts as well.